Collaborative family law can't be right for everybody who is experiencing marriage breakdown. I think it's really important that each person who is embarking on the process of unravelling a relationship does so from a position of complete information about the different ways that a marriage can be unravelled. Where collaborative family law works best is where somebody really wants to reach out for a solution that they know they will be content with and their estranged spouse will be content with, and not necessarily in that order.
There are cases where it's not possible to have a collaborative case. There may be cases of extreme violence where one party dominates the other, and it's not possible, even with the assistance of life coaches or whoever, to bring them onto an even plateau in terms of discussions round a table. And so there are definitely cases where the conventional process is the only one that's available. What's important is to try and assess whether a case is suitable for collaborative, and to ensure that the clients themselves are given the menu of options that are available for the different processes, and that they then choose which is the most appropriate for them.
Obviously, there needs to be a level of legal knowledge if collaborative law is going to work effectively. But arguably, the soft skills which those who are trained in collaborative law have are at least as or more important. This is a process which is all about facilitating discussion, and so the lawyers need to be skilled not only as legal practitioners but also as facilitators, and we are trained over many hours in order to become effective at doing just that.
Legal knowledge is only one part of the collaborative process. That's something that clients have really got to understand. No longer is the client instructing the solicitor to use what the client views as the full force of the law to get the best possible result for that person. The skill of two collaborative family lawyers working together is to share what their opinions are as to the legalities that might surround this couple's situation, but to be aware that that's only one tool that this group of four people have to resolving the issues that arise. And quite often it will be an issue of practicality and common sense rather than a strict application of the law that will provide a route out of a couple's difficulties.
Sometimes you see a client and they're not in a good place, and they may have been left, there's great emotional issues, they're frightened for the future. So either into the four-way meeting we can bring a life coach, or we can refer them to a life coach so they can help them come to terms with the breakdown of the marriage, so that when they come back to the four-way meeting, and it doesn't happen overnight, it can take a long time, depending on the length of the marriage, the reason for the breakdown, but then they come back into the meeting and they're more prepared to deal with their finances, their children, having had some help and some support on the emotional issues.
But lawyers aren't trained to look at financial products in the same way as we are. They're not trained to ask the same types of questions to get the future ideas out from clients, get the aspirations out from them. And so we work with clients to bring those to the fore and make sure that they have in place what they need going forward.
Training is offered in England and Wales by a body called Resolution. Most family law practitioners who have the kind of ethos that's needed for collaborative law are in any event members of that organisation. And the training is offered over a 3-day period initially, but every year we continue with our training, so it continues to build up as our practice builds up. The kind of skills that we are given at our training tend to be soft skills. We learn how to listen to people. We learn to do what's called active listening. We learn about reframing questions. It's all about facilitating discussion.
Lawyers have seen a sea change in the way that we're trained when dealing with collaborative family law cases. The emphasis is not so much on the law itself, which is a given, and anybody consulting a solicitor can expect a solicitor to know the law. But what collaborative family law has required us to do is to look at a whole different skill set around skills involving mediation, around looking at options, around communication, and that's not just the lawyer's ability to talk, which I think is very well known, but the lawyer's ability to listen and to hear precisely what's being said by everybody participating in the process.
It wasn't until I did the training that I realised the extent to which I am very often driving a particular outcome for the clients, hopefully because I consider it's in their best interest and that's what they've told me they want. But it has been a completely different experience to learn about really listening to what other people want, facilitating that and keeping myself out of it.
If a family lawyer wanted to train as a collaborative lawyer, then they need to be qualified for 3 years, and then they would go on a course and they would learn about the process, which is a very different way. It's a very new way of us working. You need to build up trust with other lawyers. You need to go into a meeting knowing about transparency. Knowing it's about finding a fair solution for the clients.
Obviously, there needs to be a level of legal knowledge if collaborative law is going to work effectively. But arguably, the soft skills which those who are trained in collaborative law have are at least as or more important. This is a process which is all about facilitating discussion. And so the lawyers need to be skilled not only as legal practitioners, but also as facilitators. And we are trained over many hours in order to become effective at doing just that.
Ultimately, it isn't divorce that does the damage to children. It is conflict. Divorce is a major life transition for parents and for children alike that should never be underestimated. But in fact, it's residual conflict that can prove deeply toxic and very damaging. Collaborative process, unlike the court process, allows support, dialogue, communication, and helps facilitate compromise. So in many ways, it achieves a much more effective and speedy solution, which can actually assist couples and their children in the recovery process.
The whole purpose behind collaborative family law is to put the children of the family right at the heart of a decision-making process, so that although parents might have fallen out as between themselves, their emphasis continues to be what's best for their children and what's best for their family overall, rather than a what's in it for me attitude that culturally I think is fairly deeply ingrained in British society.
The objective of the process is that the parties can deal with their difficult situation arising from relationship breakdown in an atmosphere of dignity and respect, but particularly taking into account the interests of any children and putting them at the forefront. And so at the end of the process, when they look back, they will think, we did the best we could. And many couples have an ongoing relationship because of children. Many couples, in fact, going through the collaborative process, maintain a reasonable relationship after the divorce has ended, because they have not been subjected to the confrontational and polarizational effect of the normal process.